I would be talking about how you could avoid nursing home spend down. So in this case, let's imagine that none of those exceptions to the transfer penalty worked. None of that works. So we're going to take a couple, because remember I said couples have a much better set of rules that we're working with because the state allows them to keep way more money. And in addition, the state allows what is called a Medicaid Compliant Annuity. It's a single premium immediate annuity, and if it meets the requirements of what the state says it has to look like, it is an excellent planning tool. So we're going to talk about a couple who one of the spouses needs to go into the skilled nursing facility. And let me see, how much do they have in assets? For those of you who are listening, we are going to send some information for you. But rather than me getting bogged down in all those details, I'm just going to do something here that's a little bit easier to follow. So let's say we have a couple. We're going to call them Betty and Fred. And let's say Betty and Fred, you know how housing prices are. Their house now is worth $600,000. And obviously, I'm coming to you from Eastern Washington, because if I said it with that emphasis in King County, you'd be rolling your eyes. But so $600,000 house. They also have $400,000 in other assets. Their checking, their savings, their investment accounts, be it in an IRA or not in an IRA. They've got 400,000 liquid assets. So Betty and Fred have $1 million. Do you think they qualify for Medicaid? Well, not quite, but we'll get them there. Remember, the house doesn't count. So that 600,000, we take it off the table. Now we're talking about 400,000. Fred's going to be moving to a skilled nursing facility. In a skilled nursing facility, the amount of money the couple can keep, he can keep $2,000. Betty can keep $154,140. So I'm going to kind of be rounding it down a little bit to 150 for ease of calculation. All right, so I said that they had 400,000 investment accounts and such. Medicaid's rule said they can only have 150. That tells me we've got what? $250,000 too much? And they don't want to spend down on anything. He's going into skilled nursing. He's going to go on Medicaid right away. Their house is fine. Their car is fine. They don't need to spend up and get a new car. They just want to keep all their money. And they've got 400,000, and Betty's going to need that money. So what are we going to do? Are we going to spend down to 150,000? Well, I think you know the answer to that. No, we're not. What are we going to do with that extra $250,000? We take that $250,000, and maybe somebody can put it in the chat. What's 250,000 divided by 60? Because that's the number of what the monthly income is going to be. So we take the extra 250,000. Betty buys a Medicaid compliant annuity. What that means is she takes this extra money, buys an annuity that Medicaid says is compliant with their rules, which means it will be a 60-month annuity. It will be an annuity that is non-assignable, irrevocable, and if Betty dies before the term of the annuity, then the state of Washington is the next recipient of what? The monthly amount that this annuity will pay is $4,166. How did we get there? Thank you for the math that's in the chat there. Is we took 250,000, the too much money, we divided it by the term of the annuity, 60 months. And from that, we calculate that Betty will get back nearly $4,200 a month, month after month after month after month. Because once Fred is on Medicaid, Betty, can continue to increase what her assets are. In other words, even though at the time of the application, she could only have 150,000 in the bank, plus this annuity. And why she can have this annuity is this annuity does not count. It's non-countable. So you take countable money, put it into a non-countable annuity, qualify Fred for Medicaid, and then Betty gets to get all of her money back month after month after month till it comes back to her. So she did not have to spend down anything at all for Fred to go on Medicaid, have the state pay for his care. And when Fred's on Medicaid, how is his care paid for? First, it's paid for from his income, and then the state pays the rest. Betty's income does not pay at all for Fred's care. That's Medicaid's rules. So that's a very, very simple example of how we can have this married couple keep all of their money and qualify the ill spouse for Medicaid. The great planning tool that we have in order to accomplish that is that Medicaid Compliant Annuity. And this is just one example. I tried to make it really simple. I would comment that if you have an annuity, like many people do for guaranteed income, you do not have a Medicaid compliant annuity. What financial person would ever sell you an annuity that says the state of Washington is the next recipient after the spouse? It doesn't happen. I mean, that doesn't make any sense. So the Medicaid compliant annuity is one that is purchased at time of need and complies with all the state's requirements. And so let's say Betty survives the 5 years. She can sell the money back. Let's say Betty dies during the term of the annuity. Then the state is going to get the money back as measured by how much in benefits they had paid to Fred as of the date of Betty's death. And if they get fully paid back, because it's a measuring thing, they don't all get the whole rest of it, no matter what his, how long he lives. They measure what's the amount of their lien as the time of her death, even though Fred's still in care for the next 5 years. Then, the children do have an opportunity potentially to be recipients of that asset, of that annuity. So that's how we can protect all of the money for a couple when the couple is alive. Now, I had earlier mentioned, I'm not going to talk a whole lot about estate planning, but I am going to say that if Fred lacked capacity, we might be facing a problem with doing that fairly simple plan I just described. The reason is that we need to take the house and we need to put it in his name, and from his name to Betty's name. Do we have a durable power of attorney that allows us to do that? Do we have a durable power of attorney that allows us to do potentially other things for Medicaid planning? Maybe it's not just transfer all assets to the spouse. It could be, but it could be transfer assets, to a trust, for example. Maybe this couple didn't see an estate planning and elder law attorney before Fred got sick and needed to go to the nursing home. So they have these standard traditional estate planning documents, not one that an estate planning and elder law attorney would do like we would do. So maybe they have a community property agreement that says, hey, on my death, everything goes to my spouse, and it's an irrevocable agreement. We don't want to see that kind of community property agreement. We want a separate property agreement that says Fred owns nothing, Betty owns everything. So Betty needs to revoke the community property agreement, and on her behalf and on Fred's, sign a new agreement called separate property agreement. But we might not be able to do that because Fred's durable power of attorney is inadequate for the type of planning that I just described. That is not uncommon for people who have not seen an elder law attorney. Keep in mind, when you go to an elder law attorney for your estate planning, we're looking at where your life is at the time you're meeting with us, but we're also thinking through all of these possibilities and what ifs all these things happen throughout the rest of your life and then following your death. So we're not just doing, oh, this is a great estate plan for where you are right now. We're thinking, what might you need for the future? And we incorporate that into the estate plans that we prepare. And a traditional estate planning attorney will not do that. Why? Because they simply don't know the types of things that we've been just talking about, because they don't do Medicaid planning.